And welcome back to our last Fair Housing Month series. Today you will learn about criminal records and the Fair Housing Act. Today we have three guests who will join us to talk about criminal records and the Fair Housing Act. First, we have Dr. Sandhya Kajeepeta. She is a senior researcher and statistician at the Legal Defense Fund's Thurgood Marshall Institute. She is also an adjunct assistant professor in the Department of Sociology at Columbia University. Her research focuses on the public health consequences of structural racism, criminalization, violence, and housing insecurity. We also have Jaquelia Bradley, who is a research and operations associate at the Legal Defense Fund's Thurgood Marshall Institute. She is an interdisciplinary scholar who is interested in the criminalization of poor Black people who live in cities. Lastly, we have Lauren O'Neill, who is a research and operations associate at the Legal Defense Fund's Thurgood Marshall Institute. She formerly worked with the Richmond Public Defender's Office and Richmond City Council. Lauren's research interests include democratic access in the criminal legal system and also the criminalization of poverty. At this time, we welcome you all. Thank you guys so much for joining us today, and you can take it over.
All right, thank you so much, Ashley. I'm just going to take a minute to share my screen. Okay. All right, can everyone see that?
Yes.
Awesome, thank you. Okay, hi everyone. Thank you so much for being here, and thank you to Ashley and the whole team at the Mississippi Center for Justice for inviting us to be a part of this amazing Fair Housing Month learning session. My name's Sandhya, and I'm joined by my two colleagues, Jaquelia and Lauren. We're representing the Thurgood Marshall Institute at the NAACP Legal Defense Fund, and we're going to be sharing about two of our recent research studies that talk about the intersection between the criminal legal system and housing security. So just a quick background on what we're going to cover. I'll tell you a little bit more about who we are and the Thurgood Marshall Institute. Then I will present about a research report that we published last year called Barred from Housing, which discusses the racially discriminatory impacts of criminal history restrictions in the housing sector. And then we'll zoom out from there and tell you about a report that's actually coming out in the next week or two. So we'll give you a bit of a preview to that report. It's called Locked Up, Locked Out, and it discusses the broader cycle of criminalization and homelessness. So the ways in which people who are already housing insecure are disproportionately targeted by the criminal legal system. And then when someone has a criminal record, are disproportionately locked out of housing opportunities. And then when someone is housing insecure, can be reincarcerated at a higher risk, creating this self-perpetuating feedback loop. So we're going to talk about that cycle and its roots in anti-Black racism. And then lastly, we'll have some time at the end for a Q&A where we'd love to hear from all of you. So just a little bit about who we are. As you all probably know, the Legal Defense Fund has a very long history. It was founded in 1940 by Thurgood Marshall, but our department, the Thurgood Marshall Institute, is much newer. We just celebrated our 10-year anniversary last year, and we do the research, archives, and advocacy side of the Legal Defense Fund's broader work. So the three of us are social science researchers. We also have archivists on our team. And given that we're in a moment where data and evidence and the accurate telling of history is really at threat right now, we see research and archives and this type of advocacy as being a really important piece of the puzzle in advocating for Black people's civil rights in this country. This is who you'll be hearing from today. Ashley already introduced us, but my name's Sandhya, and then Jaquelia and Lauren are my two colleagues. As I mentioned, we're all researchers. We're not lawyers. So rather than presenting the legal side of the Fair Housing Act and intersections between criminalization and housing, we're going to be talking about what the social science research evidence says about these topics. So I'm going to start things off with our research brief called Barred from Housing about the racially discriminatory effects of criminal history restrictions in the housing market. The first thing to know is that there are collateral consequences of an arrest or conviction that can follow someone over the course of their lifetime. So if someone is arrested but never convicted, or if they've served their time in jail, they've served their time in prison and are released, that record can still follow them over their lifetime and result in real negative consequences, like impacting their ability to get a job, impacting their ability to vote, to access social services, and then most relevant to this conversation, impacting their ability to access housing. We also know that Black people face harsher criminalization and punishment at every stage of the criminal legal system. So this includes disproportionate exposure to police stops, to arrests, and also more severe sentencing, holding all other things equal. So together, these two things produce a racial caste system that's not dissimilar from Jim Crow segregation. And when people with prior criminal legal contact are systematically barred from housing opportunities, it means that the racial discrimination that's already embedded in the criminal legal system is getting infused into the housing market, which is, of course, a market that's already rife with racial discrimination, as I'm sure you all know. So I want to talk about the extent to which criminal history restrictions exist in both public and private housing in the US. This slide opens with a quote from then President Bill Clinton in 1996. During a State of the Union address, he said, quote, "If you break the law, you no longer have a home in public housing. One strike and you're out. That should be the law everywhere in America." And that led to or preceded the passage of the One Strike Law in 1996, which led to most public housing authorities across the country adopting blanket bans against people with criminal records. Fast forwarding to today, most public housing authorities don't have these blanket bans where everyone with a criminal record is excluded, but they still have policies that are more restrictive than what is required by the law. So this includes things like unreasonably long look back periods where they're looking 10 to 15 years back into someone's history to see if they've ever been arrested or ever been convicted. They might be using arrest records alone. So if someone was arrested, but then the charges were dropped or the case was dismissed, they were never convicted, that arrest still could be used against them. They use overbroad categories of criminal activity. So considering any criminal activity, even if it has no relationship to whether someone will be a good tenant or whether someone poses a risk to people's safety. And then oftentimes they lack consideration of mitigating circumstances. So, for example, this could mean if someone had a drug possession charge but has since been regularly, consistently attending substance use treatment programming, that mitigating circumstance wouldn't be factored into a decision around whether they should or should not have access to housing. So that's the public housing side, and it really limits the public housing options available to people who have been incarcerated or who have a criminal record, which is, of course, problematic because public housing is meant to provide housing opportunities for people who are low income, and people with criminal legal contact would likely need to rely on public housing more than the average person, but they're being systematically shut out of public housing and have to then turn to the private housing market. On the private housing side, we still see that criminal history restrictions are extremely common. About 2/3 of private landlords don't accept rental applications from people with criminal history. So, again, really restricting the options available to people who are released from incarceration and looking for safe housing. The other thing I want to flag in terms of this landscape is that most public and private housing providers use tenant screening services, so a third-party company that does the tenant screening process for them. This is a growing and now billion-dollar industry of these third-party companies, and the data that they use to make these screening decisions is rife with inaccuracies. So it's a lot of outdated information and just incorrect information about people's records. Today, tenant screening companies are also increasingly using AI to produce risk scores for tenants. So they'll take all of the data available about them, whether it's accurate or not, and produce a number that tells the landlord that this person is a high risk or a low risk tenant. And then the landlord uses that number to make a decision about whether they should offer them housing. Usually the landlord has no insight into what data was used to produce that risk score. And it also means a tenant who is rejected wouldn't know what data was used against them in order to potentially contest the information that was used if there was an inaccuracy. So now getting into the relationship with the Fair Housing Act. So of course, when we talk about this, it's clear that there are a lot of issues with equity and discrimination and the way that criminal history restrictions are applied. So what protections do people have to ensure equitable access to housing? The Fair Housing Act prohibits both intentionally discriminatory practices, and it also prohibits actions that have an unjustified discriminatory effect, also referred to as disparate impact. And again, I'm not a lawyer, but I'll do my best to explain kind of the basis of what this means. So in order to make a case that there's a disparate impact that violates the Fair Housing Act, we need two different pieces of information. The first is that there must be evidence of disproportionate harm. So in this case, if we see that Black people who are applying for housing are more likely to be rejected because of criminal histories, that would suggest that maybe there's a disproportionate harm against Black tenants. The second piece of information that we need is there must be evidence that the discriminatory effect is unjustified. So either the policy is not necessary to achieve a substantial, legitimate, non-discriminatory interest, or such an interest can be served by a less discriminatory alternative. So of course, if we're building a legal case, we would need evidence related to that specific case, that specific policy. But I'm going to talk about instead a kind of zoomed out picture of what does the social science evidence base say about the evidence around unjustified discriminatory effects of criminal history restrictions generally. So first, thinking about broad evidence of discriminatory effects, we know that there is stark racial discrimination in the criminal legal system. Black people are about 6 times as likely to be incarcerated as white people in this country. And these disparities can't be explained away by differences in criminalized behavior. So it's not as if Black people are committing crimes at 6 times the rate of white people. It's really driven by racial discrimination in the system. This translates to 23% of Black adults having a felony record compared to about 8% of all adults in the US. So there's this clear disproportionality in terms of who is impacted by criminal history restrictions in the housing market. In addition to the fact that Black tenants are more likely to be exposed to the criminal legal system, we also see racial discrimination in how landlords apply criminal history restrictions in housing. So if we look at fair housing testing research, which is a way of experimentally testing how landlords react or respond to different prospective tenants based on characteristics like race or gender or age. And fair housing testing research consistently shows that Black prospective tenants with a criminal record face a reduced likelihood of accessing housing compared with white prospective tenants with a similar criminal record. So they're over and above the criminal record, there's this racial disparity. The chart on the right shows this from a fair housing test in Ohio. The purple bars show people with no criminal record, and the yellow bars show people with a criminal record. And you can see that across the board, people without a criminal record have a higher chance of housing success than people with a criminal record. But if we compare within groups, for example, we see that white men with a criminal record fare better than Black men with a criminal record and also Black women with a criminal record. So the second piece of showing disparate impact is the question of, are these effects unjustified? And of course, it depends on the specific policy, but generally speaking, these 3 factors often suggest that a highly restrictive, overbroad policy is going to result in unjustified discriminatory effects. The first piece of information is that criminal record information is highly inaccurate. So it's not actually reflecting someone's true criminal legal exposure. So common errors include outdated information or mismatched records. The criminal record of someone with a similar name to you could be linked to you incorrectly. Oftentimes there's missing disposition data. So if someone was arrested, but then the case was eventually dropped or dismissed, that outcome might not show up and it might only show that they have an arrest. And we see that Black people in particular have a higher likelihood of inaccurate criminal record information than white people. So this inaccuracy disproportionately affects Black applicants. The second piece is that research consistently shows that criminal history is not a good predictor of the likelihood of being a good tenant. So, one of the most recent and comprehensive studies looked at, I think, nearly 11,000 households and found that 11 out of 15 criminal offense categories had no relationship to whether or not someone would have positive housing outcomes. And the four categories that did have a relationship to housing success had a very small effect, and that effect disappeared over the course of 2 to 5 years. So that really calls into question these long look back periods that are not grounded in research evidence. The last point is that overbroad criminal history restrictions are not necessary for the safety of other tenants. There's no evidence that these highly restrictive policies improve resident safety. And on the contrary, denying housing access to formerly incarcerated people is associated with increased recidivism and increased neighborhood instability. So these exclusionary policies might actually have the opposite of their intended effect, where it's actually resulting in worse neighborhood safety by not offering housing opportunities to people who are released from jail or prison. Okay, so I'm going to stop there with that kind of zoomed in look at criminal history restrictions in the housing market. And now we want to flag the fact that this is not an isolated standalone issue, but it's actually one problem within this larger cyclical problem where people who face housing insecurity are more likely to be locked up. And then upon release, people with criminal records and a criminal history are more likely to be locked out of housing opportunities. And then when you are locked out of housing opportunities, you're more likely to face further criminalization and reincarceration and be locked up again. And so that's this kind of feedback loop that we want to be talking about. So with that, I'm going to transition to our report that's going to be released in the next few weeks called Locked Up, Locked Out, which talks about this broader cycle of criminalization and homelessness. And I'm going to turn it over to my colleague, Lauren, who's going to talk about the historical context of what created this cycle in the first place.
Great. Thank you, Sandhya. So, as Sandhya mentioned, we're going to talk about some recent research that the team of the three of us completed. And this research centered on cycles of criminalization and homelessness for Black folks across the country, but specifically, we analyzed Atlanta, Georgia. And so the report starts with the description of the roots of this criminalization homelessness cycle. And the purpose of my section of this presentation is to really explain that these roots are explicitly anti-Black. And so in our research, we found that Black communities in the United States have faced both aggressive and heightened policing and criminalization and incarceration compared to their peers. And at the same time, they've been denied access to safe and affordable housing. And I'm going to talk about both of those in turn in the next few minutes. And so throughout my part of the presentation, you'll learn how anti-Black racism is really embedded in both historic and contemporary policing and housing practices in the US. So let's start with the historic policing practices that I'll touch on. So it's not an accident that Black people face heightened criminalization in the US. And that's because since their very inception, US policing systems have operated to control the movement and subsequently the freedom of Black people. And so in my research, I found that many modern police forces, especially in the South, were born from slave patrols, which were first created by the Carolina colonies in the early 1700s in 1704. And these patrols served many functions, including things like apprehending people who escaped slavery or quelling revolts by enslaved people, and then subsequently unleashing violence upon them to reduce the likelihood of future revolts. And by the end of the 18th century, every single state that had authorized slavery had also authorized slave patrols. And so this created an interconnected system of surveillance and then criminalization for Black people really throughout the entire South. And then after the Civil War, localities enacted a set of racially discriminatory laws that we call Black codes. And these Black codes empowered police to, again, surveil and arrest Black people for very minor public space offenses such as loitering and vagrancy. And in the next slide, I'll talk about some of those. And this expanded practice of policing public space specifically resulted in Black people serving very extended jail sentences for incredibly vague criminal infractions. And these infractions really amounted to existing freely in public for a lot of newly freed Black populations. Once they were arrested, Black people in the South were subjected to very exploitative. Can we go back slide for just a second, Sandhya? Thank you. To very exploitative sharecropping arrangements through what's known as the convict leasing system. And so, through this system, despite being guilty of no crime at all, Black men in particular were placed by police forces into a convict leasing system, whereby states and even localities would then sell the labor of incarcerated individuals to private interests. And so this guaranteed free and exploited Black labor for the plantation economy. And scholars now mark this as kind of our nation's first prison boom was born out of the convict leasing system in the South. And I just want to mention before I move on to a couple of public space examples that this system of convict leasing that was propelled by the Black codes that I just discussed, it's rooted in the US Constitution. And so Section 1 of the 13th Amendment to the Constitution abolished slavery, but it contained an exception that I want to read out to you all. So it says slavery is unconstitutional, quote, except as a punishment for crime whereof the party shall have been duly convicted. And so this is baked into the Constitution, where the architects of our nation's earliest criminal legal system really intentionally used racially discriminatory policing and then criminal convictions to exploit Black people's labor. And then they used this to rebuild the South's economy in the wake of the Civil War. And so just keep in mind that kind of this is the birth of our nation's prison system. And now I want to talk about, next slide, please, Sandhya, a few ways in which the modern day laws that criminalize homelessness that Chakia and Sandhya will talk about in their future sections of the presentation have roots in the Black codes that I discussed. And so we in our report focus on 3 types of statutes that police public space. So that's vagrancy, loitering, and curfews, all of which you'll see on this slide. And all 3 of these really spread in the post-Civil War again period as a means of controlling these newly freed Black populations. So I'll take each of these pretty quickly in turn. Vagrancy laws are an incredibly vague class of criminal prohibitions against individuals for things such as, quote, roaming from place to place without a permanent job, home, or material resources, and targeting people for being, quote, poor, idle, dissolute, immoral, drunk, lewd, or suspicious. So you can see how vague these vagrancy laws were in the time and also remain today. And legislators enacted these vagrancy statutes really with the explicit intention, as I found in my research, to harass and then arrest and then jail newly freed Black people to serve the system I talked about briefly just now. And so I want to point out that in the 1870s, state legislatures in 40 of the 44 states passed vagrancy laws. So these laws really empowered law enforcement officers to stop Black people and demand proof of employment or subsequently arrest them for any of the many things I just listed. Again, that's 40 of the 44 states had vagrancy laws all the way back in the 1870s. Pairing with vagrancy laws are loitering statutes, and loitering made it a criminal offense to remain in the same area for really no evident reason. And again, these loitering statutes were very vague, and so they afforded police a lot of discretion over controlling the movement of Black people. And so following emancipation, police really enforced the loitering prohibitions and abused them against Black people. So I want to call out Kentucky's loitering prohibition. In Kentucky, loitering offenses included, quote, keeping a disorderly house and, quote, rambling without a job. And then violators of these loitering statutes could be rented to the highest bidder for a year of labor after being arrested. So just another way in which Black people were funneled into this criminal legal system by existing in public space. And then finally, I will briefly touch on curfews, which might be the tool that most people are most familiar with. This is an additional tool that was used by policymakers and law enforcement officers to restrict the movement of Black people within public spaces, or just totally make certain public spaces off limits at certain times. And so, a quintessential example of discriminatory curfews was that during the Jim Crow era, municipalities, local jurisdictions throughout the country turned into what we know as, quote, sundown towns. And these sundown towns banned Black people from residing anywhere within the town's borders or even entering the town's boundaries after sunset. And these were massive in scale. So historians found that local officials established sundown towns in 10,000 municipalities across the United States by 1970. And so these are 10,000 municipalities where Black people cannot exist after a certain time of day. Next slide, please, Sandhya. So I've just talked about kind of the origins of the criminal legal system and policing public space. And I want to now turn to the origins of discrimination in our housing system. And in our research, similar to the criminal legal system, we found a really long history of housing discrimination in the US. And this discrimination in our housing system has produced our modern reality, which we'll talk about, in which Black people are at a higher risk of both housing insecurity and homelessness. And so, for several decades before the Fair Housing Act in 1968, government sponsored racial discrimination in home buying explicitly prevented most Black homeownership. And so, this happened through things such as the discriminatory appraisal and lending and underwriting programs. And through these programs, the government really created the conditions of racial segregation in the United States. And it wasn't just the government that was creating these conditions, private actors acted as well. So banks working in alliance with government entities would further target Black communities with really subprime mortgage lending, with things like disparate access to credit, with the devaluation of their homes, and with other means to further entrench this residential segregation in the United States. And we specifically found really good evidence of a historic dual housing market for Black renters. And so what this means is because of discrimination in homeownership access, Black families are more likely to be renters. And then on top of that, Black renters have faced exclusionary rental policies and constrained rental options. And this started with racially restrictive covenants. And a racially restrictive covenant is an agreement between buyers and sellers of property that the buyer will not sell or rent or lease the property to members of certain racial groups. Again, as I mentioned in the last section, this discrimination is happening on a massive scale. So it was estimated that over half of all residential units built from 1900 until 1948 included these racial covenant restrictions. And in addition to state-sponsored rental discrimination and the displacement that came with urban renewal policies, these racial covenants meant that Black people were charged a higher proportion of their income for lower quality housing in significantly lower resource neighborhoods. And so they're facing this dual housing market where both, again, they're more likely to be renters and they're more likely to face constrained options as renters. And then, like I did with the policing side of things, I want to mention and acknowledge that these are state-sponsored and encouraged actions during this era. And so in the mid 1900s, the Federal Housing Administration's underwriting standards for housing explicitly required racial exclusivity. And then the federal government engaged in urban renewal processes. And through that, they subsidized the clearance and the redevelopment of certain urban neighborhoods. And they did this legally under Title I of the Housing Act of 1949. So through the FHA and their underwriting standards and the Housing Act of 1949, we see not only in the policing system, but also in the housing system, how this discrimination is private, but it's also government sponsored. And so just to briefly kind of sum up what I've talked through, throughout history, the US has really aggressively and disproportionately policed Black people. And this includes for just existing in public space. And then at the same time, public and private discrimination in housing has denied Black communities equal access to safe and affordable housing. And this is the history that these systems exist in. And I'm going to turn it over to my colleagues to tell you about how this loop that I've described functions in modern day.
Amazing. Thank you, Lauren. So, hi, everyone.
Now that you have the historical context, we want to turn to some present-day examples. So in defining the cycle, we're going to explore how the criminal legal system targets people experiencing homelessness. Next slide, please. And I want to start off by looking into some anti-homelessness laws. So as you can imagine, these laws being enforced are one way in which people experiencing homelessness are swept into the criminal legal system. And some of these laws exist on a municipal level. So the National Homelessness Law Center tracked laws in 187 cities across the nation from 2006 to 2019. And what they found through the data, unfortunately, was very clear. The number of laws banning acts of survival skyrocketed during this time. There was sometimes a close to 100% increase in bans. In one instance, there was a more than 200% increase in laws banning acts of survival. And when we're talking about acts of survival, we're talking about the activities you see on screen. So this could be sitting or lying down in public, camping, living in vehicles, things of that nature. These are activities that people experiencing homelessness have to do to survive, and they're not inherently a threat to the public. Next slide, please. And we also want to point out that the criminalization of these acts are not contained to local laws. We're seeing it on a state level as well. Analysis in 2021 found that almost every state and the District of Columbia had at least one law on the books criminalizing homelessness. So again, as you can see on the screen, the acts of survival that we were just looking at are very similar here, and they're criminalized. And so altogether, these laws are failing to meet the needs of people experiencing homelessness because it's jumping to criminalization instead of care and support. Next slide, please. And we'd be remiss to talk about what's happening on a municipal and a state level without also addressing something that's happened on the federal level. So as you may know, there was a recent Supreme Court decision, Grants Pass v. Johnson, and in this decision, the court upheld punitive city ordinances in Grants Pass, Oregon, which prohibited people experiencing homelessness from sleeping outside and using things like blankets for protection. In her dissent, Supreme Court Justice Sonia Sotomayor said that ordinances in Grants Pass had a very clear mission. They were criminalizing the status of being homeless. And we agree with the justice and further argue in our report that the data shows that many people are not just, driven out of cities, they're being swept into jail. Next slide, please. And so we wanted to understand the full scope of criminalization that people experiencing homelessness face. And we particularly wanted to understand how Black people are impacted. So here on the screen, you can see just a screenshot and a link to a data set that we looked at. This is the FBI Crime Data Explorer. It has data on a number of nationwide arrests, and we looked into it. Next slide, please, specifically to look at counts for one offense, which is vagrancy. And we see that, of course, as an act of survival that people experiencing homelessness have to endure. And as Lauren mentioned, this was an offense used back in the days during the time of Black codes to criminalize Black people. And we hypothesized that it was still disproportionately criminalizing Black people today. And unfortunately, we saw that was true. First, we saw that last year in 2025, there were more than 31,000 arrests made for vagrancy across the nation. And what was even more concerning were the racial disparities. As you can see here, Black people were arrested at about twice the rate of white people relative to their share of the US population. And as you can see here on the chart, more specifically, 21.7% of vagrancy arrests in the US were Black people, despite Black people only being 13.7% of the US population. So what we're seeing here really exemplifies the policing of public space being used as a tool for racial oppression. And again, it's not something that just existed in the past. It's something we see clear as day in today's day. Next slide, please. And as I mentioned, or I think Lauren mentioned this before more specifically, we didn't want to just look at things on a national level. We wanted to look at a local level. And so we chose Atlanta, Georgia as our case study. Before we get into what we saw, I think it's important to situate all of our everyone into a little bit of Atlanta's past to understand the present. So as you may know, Atlanta holds this interesting dichotomy of being a Black Mecca while also having a long history of criminalizing people experiencing homelessness. And one chapter of that painful history pertains to the '96 Olympics. So if you're around in 1996, you probably remember this really beautiful opening ceremony. I unfortunately was not alive, so I will just have to take everyone's word that was beautiful. But next slide, please. The part that's not lovely about the Olympics was the fact that people experiencing homelessness were criminalized. Now, research is very clear in showing that cities undergo beautification when large-scale events like the Olympics come to town, and they want to portray a certain image to tourists. And people experiencing homelessness are not part of that image. So ahead of the Olympics, we saw that Atlanta passed a lot of anti-homelessness ordinances. Next slide, please. And what's even more horrific, in addition to passing these ordinances, we also saw the building of a new municipal jail, the Atlanta Detention Center, or we call it ACDC. We could do a whole presentation on this and dissecting how folks felt at the time, but the most important thing to know today is that, many residents, rightfully so, raised their eyebrows and felt a little bit suspicious about this new jail being built right before the Olympics because they were concerned that people experiencing homelessness were going to be disappeared or sent to this jail. And unfortunately, their fears were not unfounded. We saw it in 1995 and 1996 alone. There were about 9,000 arrests of people experiencing homelessness in Atlanta, and we can imagine that many of them were sent to this jail. And even as you fast forward to today, when we look at jail log data, it shows that people experiencing homelessness are disproportionately represented in this jail. So in 2022, people experiencing homelessness were just under half of 1% of the total city population, but they were 12.5% of people booked in this jail. You don't have to be a math wizard to show that that is a very startling statistic. Next slide, please. So now that we understand a little bit of Atlanta's past, I want to bring us into the present day. The data that you see here is from what we call a point in time or pit count. It's a survey that's done every year to really just count or estimate the amount of people experiencing homelessness in one area, and they do this counting traditionally just in one night. So you can see here in Atlanta from 2022 to 2024, there was a pretty steady uptick in the number of people experiencing homelessness. And in 2024, when they did the pit count, there were 2,867 people experiencing homelessness in Atlanta. And if you're wondering how that compares to the total resident population in Atlanta, that's still, again, about probably half of 1%. Next slide, please. And the pit count doesn't just count people, it also collects a little bit of information about them if they're willing to share. This information could be their age, their gender, sexual orientation, if they're part of a family. It really can, go pretty deep into the details. But one thing we wanted to point out is, again, sort of capturing the state of homelessness in Atlanta for Black residents. Black people were overrepresented in many categories in the pit count, but we really want to call out this one statistic. 86% of the total count of people experiencing homelessness were Black. But when you look at the total resident population of Atlanta, only 46% of Atlanta is Black. So once again, we're seeing that Black people are experiencing homelessness at high rates. And additionally, they're then at a heightened risk of being swept into the cycle of criminalization and homelessness. Next slide, please. Now, as we did with national data to try to estimate vagrancy arrests, we also wanted to look at this in regard to Atlanta. And unfortunately, once again, we found some statistics that were very disturbing. Black people in Atlanta were arrested for vagrancy at about 3.5 times the rate of white people last year. Now, as you remember, when we looked at it on the national focus, Black people were arrested at about 2 times the rate of white people. So here we're seeing a much larger racial disparity in Atlanta, which is suggesting that the policing of public space is particularly racialized in Atlanta and overwhelmingly targets Black residents. Next slide, please. Now, I didn't want to leave you all on such a doom and gloom note. I did want to share something that's sort of promising, and it may exist in the city where you live, but it's a diversion program, and it's called PAD, which stands for the Policing Alternatives and Diversion Initiative. They deploy non-police alternative responders, and anyone in Atlanta can call within operating hours, of course, and ask someone to be deferred to PAD instead of potentially being arrested. And PAD can really save lives, and it can also save money. So whether you care about lives, or maybe if you're someone who cares about money, I think it's really a win-win for both categories. And so I wanted to call attention here to a cost analysis that was done just looking at part of 2022, and they found two really great things. Of the 120 people that were diverted to PAD, they found that 85% of those people would have otherwise faced criminal trespassing charges if PAD was not called. And again, they would have been then caught in this cycle of criminalization and could have gotten into a really long and dark path of being criminalized and stuck. And then also what this cost analysis found is that diverting people to PAD instead of incarcerating them saved about $524,000 in incarceration costs. So again, saving humans and also saving money. Now that is a really quick synopsis of what this first cycle of the criminalization process is. I will pass it now to Sandhya to talk about how people are then locked out of opportunities.
Thank you so much, Jakia. Okay, so I'm going to quickly walk through the second two phases of this cycle. So first, what we're calling locked out, the ways in which criminalization causes housing loss, which we've already touched on quite a bit. So as you all probably know, after someone is incarcerated and then released, finding safe housing is one of the most important steps to ensure future success and stability. However, securing housing can be nearly impossible for people who have an arrest or conviction due to the exclusionary housing laws and policies that I already talked about extensively, and also because being criminalized is incredibly destabilizing and can make it hard for someone to get back on their feet and access safe housing. So we've already talked about the exclusionary housing policies, but on top of that, I want to talk about these destabilizing effects of criminalization. When someone is juggling multiple challenges, whether that be untreated health conditions, addiction, struggling to pay for food, struggling to find a job, finding a home on top of that can seem impossible or can actually be impossible. So first, when we think about destabilizing health effects, we know that people who are incarcerated have a higher prevalence of mental health and substance use issues compared to people who are not incarcerated. This includes things like PTSD, depression, and substance use disorder. And incarceration can make those existing health conditions even worse. When someone is locked up in a cage, when they're exposed to violence, to trauma, this can exacerbate these already pre-existing health conditions. We also know that people with criminal records who are also navigating behavioral health challenges can successfully maintain housing when they're given the proper resources. And that can include things like permanent supportive housing. Beyond the destabilizing health effects of incarceration, incarceration also has destabilizing economic effects. So in the same way that people with criminal backgrounds or criminal histories can be barred from housing opportunities, they can also be barred from job opportunities. We know that about 94% of employers conduct some sort of criminal background check, and many have policies that bar people who have arrest or conviction records from being hired. Many states also have laws that ban people with criminal records from obtaining certain professional licenses. So this could be a license to be a hospice worker, to be a firefighter, or a barber. And these are jobs that people could actually have been trained in and working in while they were incarcerated, being paid pennies per hour. And then after their release, they might be ineligible, from getting licenses to do these jobs after release. This results in an unemployment rate among formerly incarcerated people that's 5 times higher than the national rate. In addition to inaccess to job opportunities, we also know that criminal legal fines and fees add additional financial burdens on formerly incarcerated people and their families that can create insurmountable debt and make it very challenging to access housing. So this manifests in rates of homelessness that are much higher among formerly incarcerated people compared to people who have not been incarcerated. So formerly incarcerated people are almost 10 times as likely to be homeless compared to the general population. This rate is even higher for formerly incarcerated Black people, who are 1.6 times as likely to be homeless compared to formerly incarcerated white people. This chart at the bottom shows rates of sheltered and unsheltered homelessness. And you can see the top row is the general public, where rates of unsheltered and sheltered homelessness are relatively low compared to formerly incarcerated people who have much higher rates of homelessness. And you can see, for example, that formerly incarcerated Black women face the highest rate of sheltered homelessness of any group. As Jakia mentioned, we zoom in on Atlanta, Georgia as an on-the-ground example of how this cycle plays out. One thing that makes this cycle even worse is the affordable housing crisis, which is impacting Atlanta and many cities across the country. And Black Atlantans in particular are especially impacted by the affordable housing crisis. This chart shows the number of households that are cost burdened by race in Atlanta. Cost burdened meaning that they spend 30% or more of their income on housing and utilities. And you can see that there are 147,000 Black Atlanta households who are cost burdened compared to 104,000 white households. There's also a lot of laws that can either make this cycle better and start to break the cycle, and there are a lot of laws that can make it worse and keep perpetuating it. So I'm going to talk about various laws that do either of these things. There are two Georgia statewide bills that were introduced but failed to pass and turn into laws that would have actually helped break this cycle. One is Senate Bill 157, which would have created new pathways for people with criminal records to obtain occupational licenses, and Senate Bill 512 that would have restricted and sealed criminal records of first offenders from private background checks. So both of these would have helped break that chain between incarceration and a criminal record and inability to access housing, but unfortunately they both failed to pass. There are two laws I want to highlight that have been successful in helping break this cycle. One is the Georgia Safe at Home Act, which requires a 3-day grace period before an eviction. So Georgia used to be extremely strict, in which a landlord could notify a tenant of an eviction and evict them on that same day. So this law at least requires a 3-day grace period. And I also want to highlight an Atlanta city-specific ordinance that adds criminal history as a protected characteristic, which means that someone cannot be discriminated against either for a job opportunity or a housing opportunity because they have a criminal record alone. It's still unclear the extent to which this is being implemented, because I think many people don't know that they could bring a challenge based on this ordinance, but it's really exciting to see Atlanta lead the charge in this way. It's the first city to enact a law like this. There's also a set of harmful policies that I want to highlight called local crime-free housing programs, which exist across the country, including in the Metro Atlanta area. They are partnerships between local police departments and landlords that encourage landlords to have stricter admissions policies to their housing. So basically, the more they ban people with criminal records, they get a certification by the police department saying this is crime-free housing. And as you can imagine, this has really harmful discriminatory effects for Black prospective tenants and limits their housing opportunities. Okay, so now I'm going to transition to the last part of this cycle before we talk about some recommendations that we have to help break the cycle. The last part is what we call locked up again, and it discusses how housing insecurity can cause reincarceration, which kind of feeds this loop. So I want to highlight that throughout the criminal and legal process, people have to meet certain conditions in order to avoid being incarcerated. So, for example, people who have been arrested may have pretrial supervision conditions that they have to meet in order to avoid going to jail. And then if someone is sentenced to probation or parole, they might have conditions that they're required to meet in order to avoid prison. However, the criminal legal system is not designed to accommodate people who are experiencing housing insecurity, which can mean that they face heightened challenges in meeting all of these conditions and avoiding being incarcerated. One of the first challenges that is posed to people is attending court hearings. So often when someone is arrested, they face a choice between paying a fine or showing up to court. And this is especially true for these municipal low-level offenses that people experiencing homelessness are often charged with. Both of these options are often infeasible for someone who's experiencing homelessness. They might not be able to afford a fine, and showing up to court can be really challenging if you don't have a stable mailing address. You might not receive a court notification. If you don't have access to a computer or the internet to look up when your court appointment is, and then if you don't have access to transportation, it can be really hard to show up to a court hearing and know when to be there. In nearly every state, missing a court appointment leads to more severe penalties, including additional fines, new criminal charges, and then heightened sentences for imprisonment. So in this way, one failed court appointment or one missed court appointment can result in a kind of mountain of debt and criminal charges that snowball from there. People who are facing housing insecurity also face barriers to pretrial release. They're often seen as being less worthy of pretrial release, and having a stable address is oftentimes a mandatory condition in order to be granted pretrial release. So people who are homeless or housing insecure are often punished for that status and not granted release and held in jail to await their trial. This means that people experiencing homelessness are held in jail longer on average and are about twice as likely to be booked into jail multiple times compared to people who are not struggling with homelessness. So you can see how it feeds that loop. So next, getting into community supervision, referring to probation and parole, we know that about 3.7 million adults are on community supervision, either probation or parole, at any given point in the United States. This is a huge number. It's double the number of people who are incarcerated, which really shows how wide the breadth of the criminal legal system is. And a disproportionate number of people on probation and parole are Black. So Black people represent 14% of the US population, but they represent 31% of people on probation and 35% of people on parole. So the disparities that we see in jails and in prisons also extends to probation and parole. Probation and parole comes with a very long list of restrictive conditions. This can mean you have to regularly check in with your probation or parole officer, submit to drug tests, you can't violate any laws, you often have to avoid specific people or places who are deemed risky or off limits. You often have to pay supervision fees, so you have to pay to be on probation or parole, and you're often required to maintain stable employment, and then most notably for our conversation, you're often required to maintain stable housing. So rather than receiving support and finding housing, you are punished if you fail to maintain housing and risk violating probation or parole and being reincarcerated. In 2023, we found that 200,000 people were admitted to prison because of a probation or parole violation. So this is a common route by which people are reincarcerated. And of course, housing insecurity can increase the risk that someone will violate one of these conditions and then be reincarcerated. The last barrier that I want to highlight that makes it more likely that someone experiencing housing insecurity will be reincarcerated is the lack of reentry resources available to folks who are reentering society. We know that less than a quarter of state departments of correction have a formal policy to ensure that all people released have adequate housing when they're released. Many cities and states also lack sufficient housing availability for formerly incarcerated people, including permanent supportive housing. We're just not funding these programs, and so there just isn't enough availability for people who need it. Formerly incarcerated people are more likely to be charged with a new crime or receive a technical violation if they don't receive housing after release. So we know that offering someone permanent housing can help prevent a new charge or a violation of probation or parole And that's shown in evidence, but we're often just not offering that to people. So again, I want to highlight Atlanta as a particular on-the-ground example. Data shows that about 86% of unhoused Atlantans who have been incarcerated at the city jail had at least one failure to appear warrant. So it shows how, at a very high rate, people who are unhoused and incarcerated have a really hard time meeting their court appointments, and that's resulting in them being incarcerated. As of 2023, so pretty recently, Georgia passed a law that requires cash bail for anyone who has a failure to appear in the past 5 years. So that means that unhoused people who have a higher risk of failure to appear are going to be set with cash bail and not eligible for pretrial release because of this law. We also know that about 38% of all prison admissions in Georgia are due to violations of probation and parole. So in Georgia, it's a very common mechanism through which people are being held in prison because they violated some condition of probation or parole. And Georgia notoriously has very long probation terms and long lists of restrictive conditions. We also know in Georgia that Black people are 1.7 times as likely to be admitted to prison due to a parole violation as white people. So we see this racial disparity in the extent to which people are being violated on parole and then reincarcerated as a result. Okay, so we've detailed the ways in which this cycle kind of feeds itself, but we now want to shift to kind of more optimism about strategies that we think could help break this cycle. So I'm going to turn it over to Lauren to take it from here.
Thank you. I'm going to quickly walk us through our housing recommendations, which will come as no surprise given Sandhya's barred from housing content as well as the locked up report content that we just shared. And the first of our recommendations is to reduce criminal history restrictions in housing. As Sandhya discussed, Black people are disproportionately impacted by criminal history restrictions in housing, and you've now heard how that mechanism works. And so we advocate for state and local governments, as well as private landlords, to adopt less restrictive housing policies and also follow best practices for non-discriminatory tenant screening, as Sandhya described at the beginning of this presentation. Our next recommendation is to adopt housing first. So housing first is an evidence-based approach to reducing homelessness. And how it works is it helps people obtain permanent housing as quickly as possible and offers them access to voluntary behavioral health services as needed as they're obtaining that permanent housing. And research has shown that housing first programs are really effective at reducing arrests and then incarceration. And so I want to highlight the New York City Housing First program. A Housing First program in New York City members of that program spent an average of 95 fewer days in jail over a 10-year period than members of a comparison group. So that's 95 fewer days over 10 years that these people are spending in jail because of the Housing First approach. And then finally, we in our report, advocate for investing in safe shelters and also support services. You just heard from Sandhya how most states just do not have enough shelter beds to accommodate folks who need them. So most states don't have enough of those shelter beds to accommodate 80% of their homeless adult population. And then some states don't even have 50% shelter capacity. And we know that shelter capacity is not a long-term solution to the affordable housing crisis or to criminalization of homelessness, but we do think that state and local governments really need to prioritize both building shelter capacity and building out long-term investments in housing for the citizens of their state. And so ultimately, we advocate in our report that jurisdictions really need to invest in fostering cross-collaboration to address homelessness. So we advocate for them to connect people experiencing homelessness with housing and healthcare and other social services they need to take this wraparound approach to supporting the individuals in their state or in their local jurisdiction. Those are our housing sector recommendations, and I'm going to turn it over to Jakia for our criminal legal sector recommendations.
And that theme of giving people care via services is really something that's highlighted in our criminal legal system recommendations as well. So as we mentioned throughout this presentation, laws that criminalize acts of survival do not address serious public safety concerns, and instead they're just trapping people into the cycle of criminalization. So very simply put, our first recommendation is decriminalizing poverty and homelessness. Second, we recommend reducing pretrial incarceration. And here we can really see the many actors in the criminal legal system working in concert towards a shared goal of decreasing the number of people held in jail. So one way this could be done is by having local courts and the practice of issuing warrants for unpaid fines related to quality of life offenses. Another thing that could be done is having local legislators and the use of cash bail to detain people. Third, we recommend eliminating overly restrictive community supervision conditions. So Sandhya explained this, but in short, again, people on probation or parole could violate their supervision conditions simply by not having stable housing or employment. So instead, we really recommend that state lawmakers work with judges and work with supervision agencies to amend these conditions to be more feasible. And that can be done, for example, by shortening the term lengths. And lastly, let's invest in reentry services that really support people. Right now, many state correctional facilities just do not ensure that people have access to safe housing before they're released. So state and local governments should really establish adequate and permanent funding for reentry programming. And this could include safe and affordable housing opportunities for formerly incarcerated people, while also making sure that it's accessible to job centers. So those are all of our recommendations, and I will pass it to Sandhya to close us out.
Thank you, Lauren and Jakia. And thanks all of you for listening. And I realize that we've been talking for a very long time. So we would love to hear from all of you. We're happy to answer any questions that you have about anything we presented. And also, we'd love to hear from you in terms of how what we've shared about this cycle of criminalization and homelessness shows up in your work or has shown up in your life. We're curious if any of the policies that we've described occur in your community that either makes this cycle worse, or if your community has explored any recommendations that might help break this cycle. So we'd love to hear from you. I will stop sharing my screen so I can see. And thank you all so much.
You can type your response in the chat, or if you raise your hand, I will provide permission on the function to speak. So we do have a question, and that question is, what do you all recommend to decriminalize homelessness and poverty?
Yeah, thank you all. Thank you for that question. I can start and happy to turn over to Jakia and Lauren if you want to jump in. But I think there are a lot of strategies that can be done to decriminalize homelessness and poverty. A lot of the laws that Jakia mentioned that are on books that criminalize, for example, sleeping in a car, sleeping in a public place, those don't need to be criminal penalties. And in fact, when many of us do those things, like for example, if I fall asleep on the subway or if I fall asleep in a park, I'm not criminalized. And it's really racialized and really affects people experiencing poverty in a disparate way. So there have been jurisdictions that have decriminalized these activities of survival. I think one example is in Boston, where the local prosecutor decided they would not be bringing criminal charges related to things that are currently crimes that are actually just acts of survival or are things that someone in poverty would do out of desperation that have no bearing on public safety. So instead, an issue like that could be diverted to calling 311 for support or calling a program like PAD. Like if someone is having a mental health crisis, for example, that does not necessarily need to be criminalized, but could be diverted to another public health-based service. Happy if Jackie and Lauren want to jump in and add, please go ahead.
If not, we have a comment that states that the report was eye-opening. We have another question that says, how can we help clean up poverty when you know they are homeless, yet they are not willing to accept help?
I'm happy to start again, and then Jakia or Lauren, please jump in. One thing that I live in New York City, and one of the problems here is that the only option really available to people who are experiencing homelessness is to go to a shelter if a shelter bed is available. And shelters are notoriously unsafe. There's nowhere for you to put your belongings, so you risk having all of your possessions stolen. Violence is quite common in shelters, and so there are many very reasonable reasons why someone would be hesitant to go to a shelter because it doesn't seem like a safe option. And so that's why we really elevate housing first as one of our models that we're hoping jurisdictions can strive for, because being able to offer someone an actually safe, permanent housing option and not making it contingent on certain requirements can help someone just get their foot in the door of improving stability so that they can get the rest of the parts of their life together, because housing is usually the first step in that process of stability. And I see a question about PAD being available in other areas. PAD, like the name of PAD, the Police Alternatives and Diversion Program, is specific to Atlanta, but many other jurisdictions have either already implemented or are in the process of implementing very similar programs. Actually, Lauren and I helped convene a group of folks from across the country that are all doing these types of alternative work. Actually, if you don't mind, Lauren, since I've been talking a lot, I'd love to have you share a little bit about that convening and kind of what different jurisdictions are trying.
Yeah, of course. So, in that convening, we brought together primarily groups of advocates from Atlanta, including PAD, as well as from Tulsa, Oklahoma. But we had folks from across the country. We had representatives from Oregon. We had community members from the Bay Area who came and shared the approaches that local organizations are taking in their cities. So, I think what came out of that is that there are sort of two models right now. There's a model similar to PADS where this wraparound support program and the alternative responses that come with it are embedded within diversion systems within local government. And so they're affiliated with sometimes police departments or prosecutors who are able to divert people experiencing mental or behavioral health issues or homelessness into a system like PAD where they can get them the support that they need. Other cities, if your state or local government is not amenable to diversion programs kind of on this large of a scale, then we did hear from advocates in other cities who implemented real community-based foundational programs that are doing this work outside of the context of their local government. And these programs were also very successful. And we heard about kind of the wraparound supports that they offered, the community-based responses that they offered. And these are for things, again, such as homelessness, but also mental and behavioral health issues. There are quite a few programs across the country that focus on mental and behavioral health response, in addition to issues of poverty and homelessness. And so we had a great sample of organizations throughout the country. And I would really encourage anyone to look up what might be in your community, look up what might be across Mississippi or in your state if you're not based in Mississippi, and see what other examples are out there, because it seems like there are a few different ways that localities could take this, all with really great success compared to criminalization and incarceration for community members.
Do we have any other questions? This topic today, it reminded me of a book that I read recently. It's called In Housing for All, The Fight to End Homelessness in America. And it talks about the policies and how many policies has been established in America, basically targeting homelessness and how specifically an attorney, how she is basically her for over 20, 30 years have been reaching out to legislators, going to court to fight against homelessness. So this topic today definitely reminded me of that. So if you guys are looking for a book recommendation, that is In Housing for All, The Fight to End Homelessness in America.
Thank you, Ashley. I'll add it to my list.
So if we don't have any other questions, I would like to thank you all for joining us today. The topic was very informative, and we thank you for sharing your report with us. We thank everyone who attended, all the attendees. If you definitely have been with us throughout the entire month of April, we thank you for joining our weekly sections. This is our last session of April is Fair Housing Month, but if you are looking for any other type of targeted presentations, please make sure you follow the Mississippi Center for Justice social media, and you will be aware of other presentations that we have coming up. Also, at the end of this presentation, you will be directed to complete a survey, and it is just asking questions about the April is Fair Housing Month series. Again, we thank you all. We hope that you have a great rest of your day, and thank you again.
Thanks so
Thank
much,
you.
everyone.
Okay?
Yeah, thanks everyone for joining.
All right.
Thank you.
Thank you.
Bye.